Business immigration information every week on Tuesday at 5 p.m. Central Time. Along with me is my business partner, REDDY NEUMANN. Emily?
Thanks for joining us today. I have to say, go Astros. They're playing right now, I believe. I have no idea what the score is, but I just have to say it because we're in Houston. Anywho, today we're going to be talking about a common issue that we're seeing right now, specifically for F-1 students who had filed a petition in the H-1B lottery and received the approval. Situations where that H-1B was later withdrawn, or they want to continue in their F-1 status and their SEVIS record is terminated. We're also seeing this where they requested consular processing and planned to continue their F-1, the SEVIS record is terminating. So what to do if you find yourself in that situation. We also have updated information about the public charge rule. It was a big topic in the news last week about the courts blocking that rule, but they only blocked part of the rule. There's another rule that actually went into effect today that impacts visa applications at the consulate, so we'll update you on what's going on there. We also have information about USCIS using the Occupational Outlook Handbook. We've been talking about that for quite a while, about how they use it for determining specialty occupation, what the education requirements are for a particular job. The Labor Department has different ideas on whether that's even proper for USCIS to be relying on. Also wanted to talk about 485 EADs. So for those that finally have their priority date current and have filed the 485, in the past, we used to get the EAD and the advanced parole in about 90 days. Now it's taking much longer. How long does it take and what can you do about it? And lastly, just wanted to talk a little bit about travel while you have some kind of application pending, depending on what the application is, whether it's an extension, whether it's a change of status, whether it's just a simple EAD. All of that will determine what kind of impact your travel will have on your pending application.
Emily, as you rightly pointed out, student visa people, if they apply for a change of status and they got the change of status approved from F1 to H1B and their SEVIS is terminated, which seems to be perfectly all right to me that their SEVIS has been terminated, should be terminated on October 1st. But however, we have seen the scenarios where people have applied in the consular processing. Now I'm going to ask you questions by subject wise. Let's say, for example, a person is on F1 visa and he applied for the consular processing either because he's on the day 1 CPT or for all other obvious reasons. And he applies for the consular processing and the H1B is approved and they are terminated from the SEVIS system. What can they do?
Yeah, that one is definitely a clear error because consular processing should never have been terminated in SEVIS. You should be able to continue your status. You need to bring your approval notice to your school, designated school official DSO in the International Students Office and ask them to request a data fix in your SEVIS record to bring that back to an active status, because that clearly is an error and the approval notice showing that it's consular processing should easily fix that.
Emily, if the person's H1B is actually denied and then still they have been terminated from the SEVIS system, because that if it's denied, they should not have been terminated. But we see sometimes H1B is denied and then still they're terminated from the SEVIS system.
Mm-hmm. Yeah, so I think this is a good lesson to all students. If you had anything pending in the lottery this year, if you plan on continuing your F1 status, just check with your school and make sure that your SEVIS is active. And then if it's not, in the situation where the H-1B was actually denied, assuming the denial was not due to an F-1 status violation, you should again be able to take that denial notice copy to your school, have them request a data fix in the SEVIS system, and that should be relatively easily corrected.
What if, Emily, the H-1B has been approved and the company has withdrawn the H-1B on September 15th and the withdrawal acknowledgement came on September 25th. In that case, they are still terminated. That means that H-1B was approved but withdrawn before October 1st and acknowledged by the USCIS before October 1st. They are still terminated with the SEVIS system. What is the option for them?
Yeah, they'll need to get a copy of that withdrawal confirmation from the employer or the attorney and take that to the DSO so that they can then request the SEVIS data fix. That one should also be easily accomplished if you have the withdrawal confirmation notice.
what if the company has withdrawn on September 10th, but the withdrawal acknowledgement has never occurred, and on October 1st, they're terminated from the SEVIS system? What will happen at that time?
Yeah, this one's a tough situation because without having that withdrawal notice, my understanding is the SEVIS system will not do anything, which means that until you get that withdrawal, it can be corrected, but it can take months to get those withdrawals confirmations. I mean, sometimes 6 to 8 months. Now, are you really going to wait around 6 to 8 months and then finally get your withdrawal confirmation and show it to your DSO? Do you really think they're going to say, yeah, you're fine, and do a data fix at that point? Highly unlikely. So I think what most people in this situation have to do, if the withdrawal confirmation has never been issued, assume you're in H-1B status on October 1st, and if you're not working for that H-1B employer, you are now in the 60-day grace period of H-1B status that allows you to change employers due to a job loss or for termination or whatever reason you are changing employers. So as long as you file a transfer before November 30th, you should be eligible to continue your H-1B status and begin working for the new employer once the transfer is filed. But be aware that because on October 1st you changed to H-1B status, you're technically only authorized to work for your H-1B employer from that date going forward until the transfer is filed. Most of the time, people in this situation have already moved on to a different employer. You need to stop working for that company, get them to file a transfer, and then start again. That's generally going to be the best way to solve it. I think some people think that they can just go back to F-1 status, maybe travel, come back in on F-1 and get their OPT time back. I don't think that that's truly an option because, number one, to get your OPT time back, only a SEVIS data fix will do it, and you're not going to get that data fix without having the withdrawal confirmation. And just traveling and coming back on F-1, you can't come back on F-1 without an I-20 endorsed for travel. How are you going to get that? And once you get a new I-20, a new SEVIS record, your OPT is gone.
Yeah, Emily, in the same situation where the H-1B has been approved and it's been revoked before September 25th. In the situations where it's been revoked because the USCIS finds that they mistakenly approved the H-1B approval and they revoke it, and they're still being kicked out of the SEVIS system, and the revocation occurred before October 1st. What will happen to them?
Yeah, I think the important thing to know, yes, you should be able to get back into F-1 status by taking that revocation notice to the school and requesting a data fix, but also be aware that you're no longer considered counted in the cap. So when it's time to file an H-1B again, you're going to have to wait and go through the lottery again next year.
In the situation where the revocation after October 1st, what will happen in that?
I think that really depends on the reason for the revocation. We've seen situations where some H-1B visas are revoked due to fraud, and if that's the reason for revocation, it is actually revoked from the beginning as if it was never approved. That means you're no longer counted in the cap, have to go through that process again. If it was revoked for some other reason, such as the employer withdrew or a failure to maintain status or a failure to file an amendment or something like that that occurred after the filing, I think that you're still likely considered counted in the cap and could potentially transfer to another employer, but from outside the U.S.
Emily, on the public charge issue and the medical insurance, this is very confusing to me. Now, there is a public charge. That means that the USCIS or the Department of State or the whole government will look into whether or not a particular potential non-immigrant or immigrant is going to actually be, the government has to bear the burden of for any of them leaving, or medical. And then we have the medical insurance that is an executive order issued by the president. And then now we have this Department of State. I mean, there are two regulations that have been. One is USCIS, one is Department of State. And the court, I thought, court did not block all these things? What is all the news about?
Yeah, the really interesting thing how all of this played out last week. We knew we had several lawsuits pending on the USCIS public charge rule. So there's a USCIS public charge rule Today there's a Department of State public charge rule, and then there's a separate executive order only dealing with medical insurance for immigrant visas that's applying for the green card at the consulate. Now, when USCIS came out with their public charge rule, they basically said that they have the power to look at anyone who's applying for an extension of status, a change of status, or adjustment of status. And if the USCIS officer feels they're a public charge or are likely to become a public charge, they can actually deny and say you're inadmissible. So they went through a whole long regulatory process. We knew that this was going to start from October 15th. We were waiting for the new forms to come out. They had published a new I-129 form, a new I-539 form, a new 485 form, the new I-944 form. All of these forms, AILA had to sue to get them to actually publish them because they were not available on the USCIS website, even though we were supposed to start using them today. And then at the 11th hour, 3 different judges blocked the entire USCIS regulation. So today, we're still using the old version of the form. We're still under the old public charge rules where nothing is looked at by USCIS. At the same time all of this was going on, the Department of State quietly published its own interim final regulation on Friday after all of the courts had already made their decisions on the USCIS public charge rule. And Department of State says we're implementing a very similar rule that's going to apply all of the same factors that USCIS is doing, and it's going to take effect on Tuesday. They published it on Friday saying it was going to take effect today. Well, nobody has filed a lawsuit, as far as I know, against Department of State. It's kind of difficult to put one together very quickly, and this literally just happened on Friday. So as of today, the Department of State regulation did go into effect, and it says that at all the consulates, if you're applying for a visa stamp, you have to prove that you're not a public charge according to the USCIS factors that they put out, looking at your age, your health, your financial status, have you used public benefits in the past, what's your income going to be. All of those are supposed to be assessed at the consulate when you're applying for an H-1B visa, an L-1, an H4, a TN, any visa that you're applying for at the consulate, as well as immigrant visas. Now, the Department of State also said, we're working on a new form that you're going to be asked to fill out at the consulate as part of your visa application process. That form has still not been approved. And so today, the Department of State came out and said, because we don't have the form yet, you don't have to do anything different. Although the rule went into place, it's business as usual at the Department of State until we have this new form available. So far, we haven't heard any reports of new issues popping up at the consulates as of today, and it seems to be they're processing everything under the old rules until this new form comes out. So
it's so limbo that I think so people should be prepared that if there is any, if you're going for any stamping, if you're looking for any stamping things, you probably have to be prepared for the answers for the public charge. You should be prepared for the answers with regards to the medical insurance. So I would recommend that if you need to be careful and speak with your lawyer before you do anything. Emily, on the Occupational Outlook Handbook, now we do have a Freedom of Information that came out on the Occupational Outlook Handbook. In the Freedom of Information Act, they have given us a lot of information with regards to what constitutes a specialty occupation, what doesn't constitute. USCIS always used to rely on the Occupational Outlook Handbook. Now the Freedom of Information tells a completely different story. Can you explain that?
Yeah, so this was a Freedom of Information Act request that was submitted to the Labor Department. Now, why are they asking the Labor Department for their opinion? The Labor Department is actually the agency that published the Occupational Outlook Handbook. So they come out with, for all the different types of occupations out there, just a report, an entry about what the typical salary is, what the education is, what kind of job duties you'll do in all of these different jobs, and that's the Occupational Outlook Handbook. Well, the Department of Labor kept getting asked hey, your occupational outlook handbook for this particular occupation entry says X. Is this something we can rely on when we're trying to document specialty occupation to USCIS? And the Labor Department replied back, these are all just email communications that happened over the years, basically saying the Occupational Outlook Handbook is meant to be a career resource guide for new graduates and for people looking to make a career change. It is not meant to be used for making any legal decisions. It's not meant to provide any legal arguments. So basically the Department of Labor is out there saying USCIS should not be using this as a basis for determining what education requirements are there for any particular occupation. Yet we are still seeing constantly specialty occupation RFEs that refer to statements in the Occupational Outlook Handbook. So I think based on what the Labor Department is saying, we should be able to fight back in that and say, you're not supposed to be using this at all. Even the Labor Department says, there's a little disclaimer in the Occupational Outlook Handbook online that says this is not to be used for any legal basis. So I think it's just another kind of arrow in the quiver of immigration attorneys and employers who are trying to fight these ridiculous specialty occupation RFEs where USCIS focuses on one word or one phrase within the entire report to claim that a job doesn't require a bachelor's degree in a specific field.
Yeah, in cases, some of the cases, Emily, is that even for pharmacists, they would say that it does not require a bachelor's degree. I mean, it's very odd that, where in the pharmacy that I ever know of, a person who is working as a pharmacist, doesn't have a pharmacy degree. Coming to the I-485 EADs, I mean, this used to take, I-485 is adjustment of status. When we used to file the EAD applications, it used to be adjudicated in 90 days. In fact, the USCIS have given the instructions to adjudicate those cases in 90 days. They took the rule away now. So now they're taking about 9 months for them to adjudicate the H4, the adjustment of status EADs. Now, they have given exemption that for those people who are applying for the extensions of the EADs, they can work up to 6 months after their EAD expires. But for the initial applications, that rule is not applicable. When they're filing an adjustment of status, if the EAD is not approved, they can't work. But if they're filing an extension, though, they can work up to a period of 180 days. So I want everybody to be aware that if you're in 485, if you're planning to file an EAD, I would recommend that you file approximately around 170 or 175 days before your EAD expires, because USCIS is taking 9 months to adjudicate those applications. For those people who are applying initially for the EAD application, and for those people who are applying, late extensions, I mean, they have applied extensions, I would recommend that you join the litigation that Reddy Neumann PC does for these delay of the applications. You can contact our office, or you may contact any of the other offices that are willing to litigate the cases. Our office clubs together these EAD applications because it's taking long period of time. They're supposed to take only 30 days for these kind of applications, administratively, but they're taking a long time. We would recommend you to contact if you're going out of job because your EAD expiring. You may actually want to go to the litigation and get those things adjudicated faster. Emily, these EAD taking 6 to 9 months also is impacting the travel things, especially when people are applying for the advance parole in the adjustment of status. One rule is that while the advance parole is pending, they are not supposed to they are not supposed to travel outside the country. If they do travel outside the country, the advance parole is invalid, and that's a very dangerous situation. People will be in a very critical situation. The same time, what I was speaking about the EAD and advance parole, what I was speaking about the adjustment of status, EAD is taking the same time for the advance parole. So people need to apply these advance parole well in advance. And if they have some emergency, I would recommend just go to the court rather than going to the congressman, service request, making an info pass appointment. They are not helping at all. So I would strongly recommend they should actually go to the litigation process as the best way. Emily, on the you have said that there are a lot of impact on on the applications when they're pending, especially when people travel when the application is pending. Can you tell some of the scenarios where when the application is pending, people travel? What are the troubles that they'll make? The first scenario that I will ask you is that, let's say, for example, if they are an F-1 visa and they applied for a H-1B change of status, what if they travel while the application is pending?
Yeah, a change of status will automatically be abandoned if you travel while it's pending. What does that mean? Your H-1B petition itself can still be approved. That's the portion of the petition that asks for your employer to confirm that they are an employer, that they're offering you a job that's a specialty occupation, and you have the degree necessary to qualify for that job. That's the petition itself. The change of status request is a separate part of the same petition where you're normally asking the government to change your status from F1 to H1 without having to leave. But if you leave while it's pending, they're going to assume that you abandon the change of status. You're going to receive your H-1B approval in consular processing. That's the same situation if you've applied for a change of status from F1 to H4. Any change of status where you're switching from one non-immigrant visa to another and applying for an I-539 or an I-129 with USCIS, if you leave while it's pending, automatically abandoned. Even if you mistakenly later get an approval notice that has a new I-94 on it, you can't rely on it because it's automatic.
Emily, in the situations where it's not a change of status, it's an extension of status, for example, H4 extending, H1B extending, what would be the scenario? What would the travel have in those things?
Yeah, so the H4 is kind of the easier situation because you have the option of going for stamping in order to get the extended H4 validity. So say, for example, you filed your H1B, H4, and EAD extensions all together. Your H1B got approved really fast in premium processing. You had to do the biometrics for the H4, and now it's stuck. We've had many, many people, rather than waiting the 5 to 6 to 8 months to 10 months to get the H4, they just leave, take the H-1B approval notice with them to the consulate, get a new H-4 visa stamp, and come back into the country. Now they've got the H-4 extended. No problem with that because you got the visa stamp and came back. You can travel while it's pending. Once you come back, your H-4 that's been pending, your I-539, should continue to be processed. You need it to continue to be processed so that you can get that approved because your EAD is dependent on getting that approved. Different situation for an H-1B who is traveling while an extension is pending. You know, if your visa stamp has already expired and you're leaving, you don't have a way to get the new visa stamp until you have the extension approved. So yes, you can leave while it's pending, but you can't come back until you have the approval, get the visa stamp, and come back.
Emily, you want to go to the question and answers? Yeah. One of the things that come out is that the question that comes from YouTube, Dhruvesh is asking the question, how do you know that you have been deactivated from the SEVIS system? Well, you can log in and it says it's completed, that's one thing. The other thing is you can always check with the DSO with regards to whether or not the status has been, whether or not your SEVIS system has been terminated. One question I have from YouTube for you, Emily, is that does the USCIS considers 12 years experience as a 4 years bachelor's degree, Emily?
For EB3, yeah. In the green card process, you cannot count experience to meet the education requirement. In the H-1B, that is allowed, but for EB2, EB3, you cannot use your experience.
Yeah, for the EB3, I mean, you don't need a bachelor's degree at all. You can always get away, Mr. Ramakrishna from YouTube, that you can always get away without having a degree in the EB3 though. Now, when it comes to the H-1B, it's a mandatory that a bachelor's degree is an absolute requirement. But when it comes to the EB3, you actually don't need a degree. I mean, you can get away without a degree completely.
From YouTube, Vijaya Prakash wants to know if I can switch jobs after filing Supplement J RFE with the current employer and while waiting for the Supplement J to be approved. So it sounds like you received a request for evidence asking for you to submit the Supplement J. At that point, you already had a new job offer and had moved employers, submitted the Supplement J with that new employer, and are looking to change again. There's no restriction on that as long as the new job still qualifies in that it is in the same or similar occupational category as the original job that you were sponsored for. You do need to submit another Supplement J, even if they still haven't finished adjudicating the first one.
I think so. It's a Hindi name. It's Sinha, I guess. He has a question from Facebook. Travel documents, advance parole, he meant to say, is pending for more than 6 months. That has become a norm right now. It's taking about 9 months. Make sure that you don't make any travel while it's pending, because if you travel, you have abandoned the advance parole. You may not be able to come back if your previous advance parole is expired. So please make sure that you don't make any travel plans until you have the advance parole in your hand.
Let's see. Prashant from YouTube has an F-1 visa stamp that's expiring in December, but on OPT that's valid until next September. He'll be traveling to India in January. Are there any issues during stamping? Definitely could be issues. When you're going for F-1 stamping, you have to be able to convince the officer, number one, that the purpose of your entry into the U.S. is to study. However, you've already finished your studies and are now just coming into work. So you may have difficulty getting the stamp for that reason. The other difficulty is you have to be able to convince the officer that you are not an intending immigrant, that you are only coming temporarily and that you will return at the end of your OPT. Now, if you've been in the U.S. for several years, already completed your studies, did your OPT, did your STEM extension, you may not have sufficient ties to your home country to convince the officer that you do intend to come home after September 2020. So you may face issues and not be able to get the visa stamp. That may be a risky trip to take.
Manju from YouTube has this question. She's asking on behalf of the husband. Husband was an EAD and he started an LLC business. And now his EAD has expired. What does he need to do? Does he need to shut off? Can he stay active? I would recommend, Manju, to have your husband to contact a lawyer, because when you say your company is going to be inactive, it needs to be revived, whether or not what is inactive means. Are you still operating, and how is it inactive? It needs to be checked. Maybe the ownership need to be changed if it's not inactive. So I would recommend that you contact a lawyer immediately. And this is a good lesson that people need to learn who are an EAD starting the business. If the EAD is not extended, what will happen to the business? You may want to plan it well in advance on that.
Smriti from YouTube wants to know if we can take the date for visa stamping while waiting for the H4 extension approval. So that's the great thing about H4s and L2s, as it is a dependent visa. To get the visa stamp, you don't need an H4 or L2 approval. You need the H1B approval or the L1 approval. So assuming your spouse already received the H1B approval, you can go ahead and submit your, reserve your date for your visa stamping interview and get the visa stamp based on his H1 approval. There's no need to wait for the H4 extension to be approved.
Sriram from YouTube has this question. Is there a way for a student to check the SEVIS system, or it's only the DSO? You can always check, you can always log into the SEVIS system to see, and if it says it's complete, that means you're out of the SEVIS system. So if it's active, then you are in the system. However, there's nothing wrong, and always double checking with the DSO and making sure that the information that you have is right. A person has this question from YouTube. What if I go from Canada to India? How does the DHS and USCIS know I went to India, and can I not come back from India using the automatic revalidation? Well, here is the answer to you. Nowadays, there is nothing secret. In fact, when I spoke with the CBP officials last time I was in Florida, they said that they're trying to do away completely with the passport. I said, What do you mean completely do away with the passport? And the guys told me that, well, now everything is facially recognized. If you enter into the airport, your face is transmitted to different sources out here. And if you're thinking that people are not tracking you, well, you need to look into what Snowden, who is being tried for sedition from USA, who's been, and you need to look into what he says. Even when your phone, the smartphone, even is powered off, it's actually recording and passing the information to the government. That's what he said. We don't know the truth. But at this point of time, there is nothing secret from the government. You are traveling there, they have a tracking record. And it's, you can't, and also, if you're traveling to India, you're trying to enter into the country using the automatic revalidation, that is considered to be a fraudulent entry because you're trying to deceive the CBP on that, and you may be barred forever coming into the United States. So don't try to do anything like that.
George from YouTube is on H-1B and wants to know if it's advisable to move to a new company using the receipt notice. That's a really good question. These days, there are just a lot of denials out there on H-1B transfers. So obviously it depends on the type of company, the type of job you're moving to, whether it's a relatively safe or if it's a little bit riskier of a case. So if you are filing a transfer, I think the safest way to do it is to file in premium processing, get the transfer approved, and then join the new company. If that's not an option, if your current position is about to go away or something like that, yes, you technically are allowed to move to the new company based on the receipt notice. What you have to be aware of is if your transfer ultimately gets denied and you've already moved to the new employer, that denial puts you immediately out of status from the day of the denial. It may not be possible to file another transfer or refile in that situation. Your options are very limited when you're in that situation. You may have to leave the country.
Praveen from Facebook has this question. Any updates from H4 EAD? Fortunately, none. No updates on H4 EAD. They are still adjudicating the H4 EAD, no problem with that. But they're delaying the H4 EADs. Previously, they used to approve along with the H1B and H4 and H4 EAD, but they're not adjudicating the same thing. But if you want to get it expedited, the best way is to join the litigation, especially REDDY NEUMANN PC does litigation every 2 weeks to expedite the H4 EADs. Typically, once you file, after 30 days, you can file the litigation. Within 10 to 60 days, you will get the EAD once we file the litigation.
Vibob from YouTube, the TN visa question. Given the problems for H-1B, especially for IT people, with RFEs, rejections, low job mobility, travel problems, is TN visa better? Yes, the TN visa can be a great option if you're a Canadian or Mexican citizen. It does have a very specific list of jobs that can qualify for the TN. Computer systems analyst and potentially software engineer are both on that list. You do have to have the required education that is set forth in the jobs list. They'll tell you for this job you must have this education, and they don't accept a combination or of education plus experience like the H-1B does. But if you qualify for the TN, the benefits of the TN, especially for Canadian citizens, there's no filing with USCIS at all. You can just show up to the border and apply. You can apply at the airport. You just hand over your packet of paperwork and they will give you entry in the TN category. It's a little more complicated for Mexican citizens. You do have to schedule the visa interview, apply at the consulate first. You only get a 1-year visa and then you can come in from there. But certainly a lot easier to obtain, much fewer questions on your qualifications for it if you have the TN option.
Praveen has this question. He had a car wreck and somebody rear-ended. The insurance company is trying to settle the matter. Will it affect H-1B extension or travel? I don't think so. It will affect your H-1B or travel. If you have an insurance, I don't think so. It will affect anything at all. I'm not worried for you at all.
Raju from Facebook wants to know if I can continue working on OPT when the H-1B withdrawal was received before October 1st. but haven't received the confirmation yet, and now the SEVIS record is complete. That's a tough one. I do believe that some schools are suggesting that it's okay for you to work on your OPT during that time. I think there is some risk there because in the eyes of USCIS, you're on H-1B at that point, and you're probably out of status on H-1B if you're working for a company other than your H-1B employer. And I really question whether you'll be able to get the confirmation of withdrawal fast enough in order to get that data fix taken care of properly. I think it's maybe a safer, better option to have your employer file an H-1B transfer instead. Yeah, it's a tough situation there.
Praveen has this question. His adjustment of status interview is scheduled. His prior date is not current. Will he get the green card, or will they have to wait for the green card to be current, prior date to be current? They cannot approve the green card to you. They pre-adjudicate the application, but they cannot give you the green card when the prior date is not current.
Chintan from Facebook has a valid H-1B stamp that's good until next May, and that stamp has his previous employer's name and petition number on it. Now he wants to know if he can travel to India in December and come back using that old stamp but with a new employer. And the answer is yes, you can. If you have the H-1B approval notice with your new employer and your old employer's visa stamp has not expired, it's still valid. You can use it. Be sure to show your new approval notice and the old visa stamp that's not expired when you're entering, and check it before you walk away to make sure that they've given you the correct end date. We see a lot of times where CBP will give you the end date that's on your visa stamp, not the one that's on your approval notice. That's an error. You should get it corrected right then and there. If you don't notice it till later, you'll have to go to deferred inspection or possibly file an H-1B extension. That would be unnecessary. So that's the only risk there.
Akhil has this question from YouTube that his name has been misspelled. Will he has any problem in stamping in the US consulate with the H-1B approval? Akhil, I have not seen any problem when the name has been misspelled. They are able to look into your identification, you're in their custody. They're able to look into if you are the correct person or not. They have fingerprints, they have all different things to verify you are the proper person or not. And if you're not the proper person, they can even detain you. So no, we never had any, I never faced much problems with the people's name has misprinted and then went to the consulate. I've never seen much problem with those people. Now I've seen them problem in the driving license and social security number issuance, but not in the stamping.
Bhavya from Facebook wants to know if she can travel when the EAD is in progress with USCIS. So assuming this is an H4 EAD, for example, or an L2 EAD, and you're not talking about also having an I-539 pending, it's just the I-765 pending, yes, you can travel while it's in progress. You just had to be in the US at the time of filing. Once it's filed, you can leave and come back, or you can stay out until it's approved. No issues there.
From the Facebook, he has a foreign language. I can't read that language. Can I appeal against a H-1B decision where they put the wrong starting date in the petition? Is it worth appealing it, especially in the quota case? No. If you have filed it in a wrong starting date on a quota case, it's definitely not worth appealing the decision. I would advise you against it.
Harinath from YouTube has a 221G that's been pending at a consulate for 4.5 months, no updates, and wants to know if he can go for visa stamping again at another consulate while that 221G is in process. No, I would not recommend that. I think you might be found to be kind of forum shopping, and they're just going to send you back to the original consulate that has the 221G pending.
Mehul Chowda has this interesting question. I'm getting married in December. Can I file a DS-160 and reserve the date for the H4 visa and mention that I am married and put the married date when the marriage not has occurred? Mehul, I don't see that as a problem. I can understand that, and if you're getting married in December and you book an appointment, you say you are married, but you put your marriage date as whatever that is. I don't see that as a problem, though. Emily, do you see that as a problem?
It shouldn't be. I mean,
yeah.
it kind of makes sense.
Yeah, it shouldn't be. I mean, unless if the marriage didn't occur, I don't want you to go for the visa, but if it's, I don't see that as a problem. It might be a good step for you that, and if you mentioned it as merit though, I don't see that as a wrong. You can always say that you wanted it on the day of the interview you are. I don't see that as a material misrepresentation. It's just for convenience sake, you have just put it that you're married. I don't see that as a problem.
Raja from Facebook applied for a change of status from F1 to H4 along with the H4 EAD and wants to know what is the probability that both will be approved at the same time. In our experience, they're almost always approved together. The only time there is a gap where the H4 gets approved and the EAD gets delayed is if there's an RFE or request for additional evidence on the EAD, usually because something was missed in the filing. You forgot to submit the passport photos or you forgot to submit the I-140 approval notice or whatever the case may be. But assuming that everything was properly filed, it's very rare for them to be approved separately.
I have this question, Emily. I need your attention also. Can the institution for a H4 constitute a public charge? I don't think so. It should be a public charge because you're paying the taxes in that particular state. You're residing in that particular state. I don't think so. I myself, on H4 visa, have gone to the college with the institution. I don't think so, but do you think so?
No, I mean, the public charge rule, they're looking for public benefits you're taking for income maintenance because you don't have the income to survive. So they're talking about food stamps. They're talking about HUD housing projects that you're living in. It's not your, public benefit. I know, yes, you're getting a benefit and the public is paying for it, but that's not what they're referring to. There's a very set list. I have the list on my blog, immigrationgirl.com. One of the recent articles I posted about public charge. If it's not on that list, it's not considered a public benefit.
One question that needs your attention also. Can we file a lawsuit for the to recapture the unused green card applications?
That's a great question. I don't know if it is time barred because...
we need to, it's a good question that you presented though. We will have to refer this to our litigation director. We would come back to you guys to next week maybe and to give an idea. And thank you for the innovative advice that you are giving us. Even though the chances of success according to me may not be that high, but looking into the way the litigation process is going on right now, and you just file any case against the government, the judges are approving it. I mean, if there is any merit in it, they're approving it. So it definitely is worth for us to explore it from the YouTube. Sarata, we will explore that and we'll try to get back to you on that.
Uday from YouTube has an I-140 approved with Company A that's been approved for more than 180 days, already switched to Company B with the approved H-1B, and wants to know for the next H-1B renewal, is it necessary to have an I-140 with Company B by that time 3 years from now? And the answer is no. You can keep using the old employer's I-140 to extend your H-1B forever until your priority date is current. Even if your current employer has not started the process for you. That I-140 remains valid since it's been more than 180 days. You can keep using it.
Viv Kumar has this question, Emily. It's an interesting discussion, is that he's on 485 application. Will the H-1B extension rejection has any impact on the 485 application? Viv, one thing is that if you have an EAD that's already approved though, I may want to avoid this complete H-1B though. That's my personal opinion. There are some lawyers who disagree with me on that they want to have both those things. I have seen in some cases where the H-1B rejection getting affected the 485. I've seen sometimes they don't get affected on the 485 too. My opinion is that if you have a EAD, I would not file a H-1B extension. Do you agree or disagree with me, Emily?
Yeah, unless you're in a situation, maybe your I-140 is not yet approved and you filed concurrently, there's a chance the I-140 could get
and
denied.
It's an initial H-1 adjustment of application. It's taking more than 8 months to get an EAD. You don't have an employment authorization.
Yeah,
that makes sense for us to do the H-1B extension. Though some lawyers say that they need both, we don't see that it's needed for for the H-1B to be there.
Question from YouTube from B-Day 1981. H4 approval was not received, and USCIS is saying you have to file for a duplicate copy, the I-824, which of course costs, I think, $400 some odd and
Plus.
takes 8 months to process. So he wants to know, should I go ahead and apply for the I-824 or just go for stamping with the approved H1? I would go for stamping if you.
I have not seen any problem when the people don't have the original H-1B approval. I have not seen a problem. And I mean, one thing that we at REDDY NEUMANN PCs, that's not, this YouTube is not just, and Facebook and the daily conference call that we conduct and Emily's blog, thousands of people, Immigration Girl, is that this is a source not only that we are giving information, we are also getting information from you. And I don't think so we have seen any problems with, I would just go with the copy rather than wait for the duplicate. By the time your duplicate I-824 is processed, your expiration of the H-1B might occur for you.
Sriram from YouTube wants to know if CHIP for a child born here is considered a public charge.
Can you explain what does CHIP mean?
CHIP, it is medical insurance usually provided by the state.
Okay.
And no, it does not. It is the U.S. citizen child that's receiving that public benefit. They do not pass that on to you as the parent. So they only consider the person who's actually receiving the benefit when they're looking at public charge. So a U.S. citizen is not considered to be receiving a public benefit that would impact you. Shilpa from YouTube has a really good question. For people whose SEVIS has been completed and the H-1B withdrawal was submitted before October 1st but not completed, are they CAP exempt? So we've actually, this comes up every year. So every year in October, we end up filing transfers for people in that exact situation where the withdrawal was submitted before October 1st but not processed. So we've never had that issue raised where they said they're not counted against the CAP. Once you cross October 1st, if the withdrawal was not actually processed, you should be considered counted. Now, is there some risk? I'd say there is a slight risk that they could say, well, it was submitted before then, you didn't give enough time for them to process it or something crazy like that. But a withdrawal is not a withdrawal until it's actually done. So just because you've requested it doesn't mean it's actually withdrawn until USCIS says it's withdrawn. And I've never had them come back and say, no, you're not counted against the CAP.
Sidhu has this question that his F-1 to H-1B has been approved, change of status has been approved. Can he go for stamping to Canada, U.S. consulates in Canada? The answer, yes, you can go, Sidhu, to U.S. consulates in Canada. But I want you to be careful though, because there is about 10% to 15% denials of the H-1Bs in the consulate. I want you to be very careful. And this is where a lot of people ignore that. Oh, you got the approval, the consulate cannot deny it. Let me tell you one thing. You can't even approach to the consulate if you don't get an approval. Only the approval, you are eligible actually to get the denial. So when you are going for the consulate, whether it's a U.S. consulate in Canada, Mexico, or India, or in whichever country you are, be prepared with your application. I would suggest you to have a mock interview done by a lawyer. The reason is that you have all this future ahead of it, and you're just going, assuming that you're doing right. And when the mock interview is done by a lawyer, what I would recommend that is that you give them the H-1B approval. If there's any RFE, you give it to them, and you also need to give your social media so that the lawyer can look into it. And a lot of times, I look into it, they're going there, they're saying that they're working for ABC, their H-1B is filed with ABC Inc., but they're actually working with a different end client, let's say, Pepsi or Verizon. And in the Facebook, in LinkedIn, all these locations, it's listed that their employer is not ABC Consulting Inc. I mean, how can, when you are telling you're not working for ABC Consulting Inc. and you're going to the consulate, why would they believe you're working with ABC Consulting Inc.? That's a very simple thing that I look into it. And when people answer the question, who is your employer, they simply say their employer is not ABC, it's something else. And that's a very straight denial. I want you guys to read the petition, look into the petition, what was being written in there, and see if there is any discrepancies of what you are thinking, what your profile is telling, and if there is any discrepancies, you should contact your employer, or you should contact your employer's lawyer. Hey, I don't think so that I'm an ABC company employee. Why did you file H-1B on this company? Then the lawyer will be able to answer your questions. But don't go to the consulate and represent, I am not working for ABC company at all. I'm working with this other company. Well, your H-1B says ABC, I'm going to deny this application. These are the things that we see. Yes, you need an end client letter. Yes, we need to show the control of those things. We understand that. I want you guys also to prepare those things to show who is controlling. Is it the employer? Who's the end client? Does the employer has any control? All these things you have to be thoroughly there before you go to the consulate. And if you ever do any simple mistake, they're going to either put a 221G or deny the application. You're out. Be careful when you're going for stamping. Any visa. I've also noticed that recently some of the H4s are getting rejected. So why would the H4 be rejected? I looked into the Facebook. Well, both are showing they're not married. Why are you showing you're not married? Your Facebook is active. You're going with the other guys, and you know your other friends. You have the picture, but you are saying that you're not married. You're single. That's definitely an issue for me. If you're telling you're single and you're telling the consulate to give an approval, I have a problem with that.
Supreet from YouTube has a really good question. My H-1B was approved through change of status. Since I'm already on H-1B now, does the consulate still have the power to make a decision on my application? I already got the petition approved. Yes, they absolutely have that power. They're looking into, one, whether you're inadmissible for any reason, but they're also looking into whether you qualify for the visa that you've applied for, and whether anything stated in the petition is actually not accurate compared to what you're saying at the consulate. And absolutely, the consulate can deny the visa stamp and send your petition back to USCIS with instructions to revoke it due to whatever happens at the interview.
Emily, any update on the Washtech litigation, OPT STEM extension litigation?
I haven't actually looked lately, and I haven't heard anything in the news, so I don't think any action has happened on that.
The same question is the Senate 386 bill. There has been a rally last week in the Chicago. In fact, I'm also going to Chicago this week. We'll try to see if I can meet with Senator Durbin's office. Senator Durbin is the person who's putting on hold, so we're going to try to see if we can see anything on that. But I want you guys to keep in touch with the senators, keep on writing them letters. Please don't just go to the White House petition and just fill that thing and be satisfied that you did your thing. No, you didn't do your thing. This is your life. I want you to write a detailed letter to the senators, detailed letter to the congressmen of the local constituencies where you're located at. Well, my senator is already in favor. Still write a letter to that person. You need to thank him for supporting him. You can take a draft of the letter from the Immigration Girl blog, which Emily hosts it. It's at Immigration Girl. You can take a draft of it and use that in sending the letter to the senators and to the congressmen.
All right, so Rob wants to know, if traveling to Canada for less than 30 days and you have the option of going for stamping or automatic revalidation, which one is better? What are the risks involved with automatic visa revalidation? I think the risks are much lower with automatic revalidation. They're not going to be re-adjudicating the petition like we just talked about when you go for a visa stamping. At the port of entry, those officers are looking to whether you qualify and your intention is correct for the visa that you're entering on. But I see very few people have trouble with automatic visa revalidation compared to stamping. A lot of people get stuck there. So.
Sriram has this question from YouTube. Seems to have a lot of questions. EB1 outstanding researcher. Does it has to have a tenure track position offer? Can he do the self-filing? EB1B option, if it is done by the university, has to have a tenure track. That's an absolute requirement. The second requirement is that it has to be filed by an employer. EB1B, which is the outstanding researcher that you're citing, cannot be filed by an individual. It has to be an organization. If it's a university, it has to have a tenure track. If it's not a university, it doesn't, tenure track is only for universities. So they can still file it, but it has to be an employer. An individual cannot file it. An individual can file EB1A, which is extraordinary ability, which is very hard to meet as compared to EB1B.
Divya from YouTube has a question. She applied for her STEM extension after the expiration date of the initial OPT because she was waiting for a SEVIS data fix, and it took some extra time. Do you think USCIS will consider this as a valid case because the reason for the delay was due to DHS's own mistake? I think that it's going to be a tough case. I hate to say that. Probably would have been good to go ahead and file the I-765 without the I-20 and file it timely and then wait for the RFE and then submit it and make your argument there. I think that simply because it was filed late, you're very likely to get a straight denial of your I-765, and then you're going to have to file a motion to reopen or motion to reconsider, and at that point you'll have the opportunity to explain what happened, and hopefully they will realize that it was due to DHS's own error. But that's the biggest problem, is just the amount of time it's going to take and how much time you're going to lose of your STEM extension trying to fight them on it. Tough situation.
A question that came from TN Visa is, will it have a problem of the dual intent if you have an I-140 approval? This comes from Facebook. Yes, that is going to be a problem for TN Visa. If you have had a I-140 ever filed, that becomes a little bit tough. Now, you can overcome that, but every time you travel, though, it may become a very tough job to convince the CBP official that this visit that you are having is a temporary visit, though. So I think so you need to discuss before you move to TN Visa if that's an appropriate thing or not.
Oh, let's see. I had a question, I can't remember who it was from, about Rima has her husband's H4 visa is already valid until 2020, has the H4 EAD applied for and pending, and wants to know if she can travel. Yes, no issues with that as long as you were legally here on the day the EAD was filed and you're not waiting on an I-539. No issues with travel in that situation.
Minac has this question: can the USCIS reverse its STEM extension denial decision? It depends on the situation. I very hate to say that. I normally don't like to use the word depends on the situation. But if the mistake has been done by the DSO, and the DSO is willing to write it down saying that it's his mistake, that that's the reason why the STEM extension got denied, you may have a chance in getting the extension denial reversed. But if it's something where you delayed it, or if the DSO did some mistake and then he's not willing to acknowledge it, you will have a very hard time in getting the STEM extension decision denial reversed.
Speaking of OPT, kind of similar situation. Sai has that situation, applied for the OPT in May, never got an update on it, so USCIS said apply again, did it a month later, but unfortunately used a reprinted I-20 rather than getting a new I-20, and the reprinted I-20 was expired by the time that the new application was filed, so the OPT was denied. Yes, I've seen that happen a number of times this year, unfortunately. I actually have filed a motion to reopen on this exact issue, and that's pending, trying to get the OPT reopened and approved. Sai is asking about whether reinstatement is an option. Yes, that is an option. You have to file an I-539 for that, get the new I-20, new SEVIS record, but you're dealing with the I-539 processing times, which may be anywhere from 4 to 8 to 10 months. You do need to attend classes while your reinstatement is in process, I believe, but verify with your school on that.
Anything else, Emily?
I think that about wraps it up for today.
Thank you very much for joining us, REDDY NEUMANN PC's weekly immigration information. So if you guys have any, you want to speak with me, Emily, or any of our talented lawyers in our office, you can always have an appointment with us. Go to RN Law Group. You can make an online appointment with me and Emily or anybody else. Please don't hesitate to subscribe to immigrationgirl.com and also at rnlawgroup.com. You know, if you're on the Facebook, you know, please like us, or if you're on the YouTube, please click on the subscribe button so that you keep on getting these weekly updates that we do.
Thanks for joining. We'll see you again next week.
Thank you.